So just decided I'm going to make this video talk just to explain this qualified privilege and absolute privilege, right? So the thing is, the Parliament Petitions Committee are being a little bit misleading on this, right? In the logic of it. And I've been through some of their reports, and they blatantly misquoted the law. Blatantly. For example, for Article 9 of the 1688 Bill of Rights, they've made up their own words for it, which actually they've taken from a quote, a well-famous quote. It may even be an Erskine May quote, but nonetheless, they've substituted the legislation for a parliamentary quote, which is not the legislation, right? For the ancient privileges of Parliament, and they're trying to pass it off as the law, right? Because they put the title of the legislation above it, and then underneath it, they frame it as this is the legislation when it's not. That's just like their interpretation of the legislation from, like a parliamentary quote, right? So on that basis, there's good reason to question a lot of these reports. I mean, Jacob Rees-Mogg said in one of the papers for the e-petitions, oral evidence, he said that petitioning was completely privileged under the 1688 Bill of Rights, but the Parliament wanted to control or restrict the right, which to me that's a contempt, right? And it's our privilege. It's not like the Lord's privilege or the Commons privilege. It's our privilege, right? So now, in these committee reports, I actually worked this out when I actually was learning about the right to petition, and I hadn't read any parliamentary papers. I actually wrote this paper called "The Requisitions of Petitioning," what is required of petitioning, and what I essentially had done is it's really my own version of a summary of the parliamentary law of agency, right? Which later on I did learn about it, but that's like what I worked out from intuition, right? Just from intuition and general knowledge. And then I actually, as I'm reading, I'm thinking about these terms like, what qualifies someone for privilege, right? And then I didn't know that these terms were being used and are well used, right? I just was reading the earlier material, and my own mind was coming up with these bases and words and themes, right, and expressions. And then when I get to reading the modern literature and the modern parliamentary papers, I'm like, oh, they're using these terms, right? Well, if they're using these terms, why weren't they acknowledging me when I was using those terms, when I learned them from scratch myself, came to those conclusions of these terminologies, and then later find out that, oh yeah, we're using these terms, these are the official terms. All right, well, I did well, didn't I? Then I worked out all the official terms, right, myself, right? And it turns out you're using them all, but you're perverting them and trying to manipulate and bend them, and also you're denying us claims when we're wanting to use them, right? Now, an important act is this Parliamentary Papers Act, because that act, like a newspaper or anyone who's sharing something, a parliamentary paper or material, can be protected under that act, and you normally ask the Speaker for a certificate, right? They're saying that the act itself is not parliamentary privilege, and it doesn't affect parliamentary privilege if you're using parliamentary privilege, but from the events which unfolded, they were claiming parliamentary privilege on the Hansard and Stockdale case, right? And then they kind of fought it in the courts, but it was meant to be parliamentary privilege covering these documents, but it got challenged. So it is really privileged, but what they've done is codified it into law, so you can use this act for certain persons if they're other persons want to qualify for privilege, right? Now, there's some things that we need to kind of like sort of set out. Okay, so when we're talking about the rights and document and any parliamentary paper or a petition, right? Let's get this clear. The right to petition is a particular right that has absolute privilege, right? So that is absolute privilege. Now, they talk about this absolute privilege versus qualified privilege. These are the terms that they use, the MPs, right? They use these terms, absolute privilege and qualified privilege. But you qualify for privilege, right? You can qualify for an absolute privilege. They're doing a con or a trick, right? If something is privileged, right, it's absolutely privileged. And you have to you qualify for that. The test is to see if you qualify for privilege, right? But what they're doing is they're saying that if something's privileged, it might not be absolute privileged and it can somehow not apply or it can be waived. Now, they use the word, right, malice, okay, malicious. But in this Samuel Johnson's dictionary, malice means something done, bad or nasty, but without a cause, right? Without a claim or a cause or reason. And that's the important part. Now, when you are doing a parliamentary cause or a parliamentary matter, you always have a cause, right? If you are doing something for Parliament, if you are doing something for a process of Parliament, right? Or if you're doing a petition, your petition is your cause, your case, right? So it's never malicious if you've got a cause, because it's with cause. It comes with a cause. A petition always comes with a cause, always. So it is never malicious. You can't have a malicious petition because you wouldn't have a petition because the petition is a cause, right? So it's always absolute privilege. It's always absolute privilege if you have a petition or cause, right? Now, when they're in, you can have these public meeting acts which say that, as long as something is not maliciously done, then the meeting is privileged, right? That means that if you're doing something which is not for the purpose of the meeting, right? Or it's not for the objectives or goals of the meeting. Now, this means that if you're doing a petitioning, okay, and you're pursuing the goals and objectives of the petition, right? Then you're covered. And that's what qualifies it. And there's something called the law of agency, the law of parliamentary agency. It's actually being qualified. To qualify for agency means that you are officially doing something, right? As opposed to not doing it, right? And this is what the word qualified is. Now, the law of agency qualifies people, right, for certain things, depending whether it's elections, but you can also use it for petitions. So this qualification, qualified, if we start talking about the law of agency, it helps explain it better. Now, the thing is that you could be doing certain things and they might not be, they might not qualify for petitioning, right? So itself, petitioning has certain activities which bring you under agency of doing that petition, which is qualification. But this is the thing, right? what they're trying to make out is that something might be privileged, but you've got to prove that it's not malicious. But when you're proving it's not malicious, you're proving that you've got a cause or case, right? So really, all you're doing is you're proving that you have an existing cause or case, right? And when you've got an existing cause or case, it's not, you're not using the word malicious. It's not regarded in the context of nasty or bad, right? I think another good word is unjustified. But here in the Samuel Johnson dictionary, to qualify, to fit for anything, right? So to furnish with qualifications to accomplish. And then here, to make capable of any employment or privilege. Well, the word employment also means to put to use, to put it to use for something. You don't have to be paid or a job. You can employ a hammer to put a nail in, right? You can employ the right to petition to achieve your petition objectives. So it actually has an entry here. Actually, the word qualify, the third example that Samuel Johnson has got, he is actually using the word privilege here. So Samuel Johnson is actually making a connection between the word privilege, to make capable of any employment or privilege. So to make it capable of being privileged, to qualify. So it's an official, this word actually is officially linked to privilege and petitioning anyway in Samuel Johnson's dictionary, which is quite notable. So now it qualifies if you actually are doing it, right? So this is the thing. If you are actually doing a petition or sharing it to other people, it is the fact that you are doing it. You either are or you aren't, right? It's either for that purpose and reason. Now, this is what qualifies it, and the right to petition is absolute privilege. And it cannot be malicious because of it being a petition and you doing it for that purpose and reason, right? Now, what the courts are trying to do is they're trying to make out that, well, okay, you might very well be doing those things, but do you intend to harm someone? Do you intend to upset them, or do you intend to damage them? Well, this is the thing. If, for example, Sadiq Khan, the Mayor of London, when he decides to put all these fines out, right, he's got an intention there to take people's money from them, right? Now, why isn't that malicious? Well, he's a mayor and he can decide to introduce fines, even if it might harm or hurt people financially, right? So he's got a cause behind him. But you might say, well, he's not actually wanting to hurt or harm them. Well, he's wanting to financially put them in detriment, right? Because they're doing a certain thing, right? Because you are using certain cars within London, I want to. But you say, well, that the taking of the money is not harmful. Well, it's harmful to them when they can't afford it, right? It's all about, the legal right, as opposed to, once it's qualified for privilege, right, and you are pursuing a certain objective, you've got a legal right to injure other parties. It's like the police, when they're chasing a criminal and they kick a door down, they've got a legal right to injure the door, right? Now, do you want to get into the argument of, did the police officer want to injure the door or not? Well, the door is injured. If he kicks it through, right, he kicked it and he injured it, right? Now, it's all to do with, was he pursuing a goal or objective or not when he was doing that? If he wasn't, then he had no cause, right? There was no cause with it. If he was chasing someone, then he did have a cause, right? And he's using the law. And what is happening currently in the courts with Extinction Rebellion and Just Stop Oil and Defend Our Juries, they're doing particular things which could be injurious to other persons or parties, right? And what the courts are trying to do is argue that they're trying to, they want to know why they did it, you know, what were the motives in their mind, you know? Did you want to harm it? Well, a policeman always wants to harm a door if he's trying to kick it through, okay? He can't not want to harm the door because he's kicking it through to get through the door, right? He wants the door to be kicked in and broken, right? No matter what definitions and explanations you give to that, okay? It's the same physical action or activity. Now, you're trying to get at the motivations behind it and the reasons, which are all subjective, right? Subjective reasons. But he's following an objective cause, right? So his subjective reasons, right? The subjective reasons are, the door is going to be injured, right, if he kicks it in. Now, it does not, as long as he's locked on his objective, right, it's actually immaterial, or when he is with cause, when he has a cause present, what it does is it makes his motivations irrelevant, okay, because the cause cancels out the relevance of any motives or motivation because it's with cause, okay? So the cause qualifies it, right? Not the subjective intention, because the subjective intention is neutralized, okay? Any assessment of the personal or subjective motivation is neutralized by the objective existing cause. The pursuit of the cause basically removes the relevance of the subjective reasoning, right? And that this is the thing with the right to petition. If you have the petition and you have a cause, and what you're doing is pursuing that, and the main thing that we're likely going to be talking about when it comes to this is canvassing, right? Advertisements, which is using the the Control of Advertisements Act, which is why it says you can use a 1688 Bill of Rights through any enactment. You can even use Parliamentary Privileges Act, right? And it is the existing cause and the promotion and advertisement of that cause which qualifies you for the privilege, which the privilege is absolute. Now, what they're trying to do in the committee meetings is say that, well, right, you might have a lot of people in a meeting, right, who are privileged, or they might have some people who are, like, the newspaper is itself not likely to be doing a petition. The newspaper is just reporting on parliamentary proceedings. So when it comes to the newspaper reports, if you've got a newspaper reporter and he's writing articles about Parliament, what was said and done. Now, if the newspaper reporter misquotes or says something nasty or attacks a certain person, right? Because it is, he might intend to harm or hurt someone, right? Now, this is the thing. What they're using this term, they're saying that just because a newspaper is reporting on a parliamentary matter, on a parliamentary paper, they're trying to make out that the newspaper does not have absolute privilege, because if he's doing an abstract or if he's doing something, of it's, his own kind of like poetic license, that can diminish the privilege. But the thing is, when you're using privilege, what it does is it's removing it out of the jurisdiction of that court, because it's under the jurisdiction of Parliament, right? And it's for Parliament to judge and decide. But Parliament might say that, they're not going to uphold the privilege. But that's for Parliament to decide. But they're kind of like letting the courts decide that. But then it's not parliamentary privilege properly, because they're letting Parliament decide it, not the courts, right? And I think this is the point in the Parliamentary Privileges Act. But they're saying malice without cause. But, the newspaper itself isn't bringing a case or cause necessarily. It's actually merely communicating parliamentary matters which of themselves are privileged. So the newspaper itself cannot be liable for any of the effects on other persons. This is always usually about the effects of these documents. What effects do they have on other persons, right? Which is why you've got all this defamation and copyright laws and all these other things which are exempted from it. Now, the reason this is important is because of all these Extinction Rebellion and Just Stop Oil cases and Insulate Britain, they're all going into court and they're not claiming privilege, and they're just doing a common law defence and giving excuses for their actions under the normal remit of common law. And if they have got a cause, if they are advertising and promoting that cause, then it should actually be absolute. It is absolute privilege if they qualify for it, but they qualify for it being a cause. Now, but what the courts are trying to make out is, is this malicious? Are they trying to harm or hurt these banks or, these corporate entities who they say that, they're harming the environment and they want the government to change the law around them? Are they wanting to cause harm to them while they're doing all these adverts and promotional things? Well, if it's public property, under that act, they've got deemed and express consent. But if it's private property, they don't. But the thing is, the right to petition is absolute privilege. So, it's meant to remove it from the remit of the courts. And I don't know whether Parliament can punish them or not, because it's meant to be our own separate privilege, which is distinct from House of Commons or House of Lords privilege. But what the problem is that they're not even arguing whether or not it is malicious or not, and whether or not it qualifies for an advertisement, and that's what they're doing, and whether it's privileged. They're just completely disregarding the whole thing. In fact, some newspapers are actually probably, some of the newspapers, when they're in some of these test cases or these earlier cases, they're actually more on the right area of law than what the actual political campaign groups are on. And this is why the first Public Order Act was meant to have the Attorney General check for privileges and give consent to prosecute, which they're not doing at the moment, so that the Attorney General is not fulfilling his role properly. And before that act, you couldn't have large numbers of people going around doing these promotions or adverts without actually getting a court order which did officially attach the privileges. It did warrant these privileges to be used by a larger number of people. But these Extinction Rebellion and Just Stop Oil are not even doing the correct area of law. They're just going into a court and then they're trying to make up excuses why they're doing something, just purely under the common law arguments, which is all under, was it a proportionate response, and that's weighing and assessing matters, but you've got to weigh and assess what the cause is to whether it's proportionate or not. And they were not meant to be allowed to touch on the cause and matters of the cause to see whether it was a proportionate response to the cause, because that cause cannot be adjudged in a court. And this is where the House of Commons before 1980 had to get consent and permission to assess whether it's a proportionate response or not. What is a proportionate response? The environmental issue is the matter of the petition, and that is a matter which cannot be decided in any place out of Parliament. So the courts are actually touching on parliamentary matters, which is exactly the basis in the Lord Hanningfield case, right? So they're not wanting to assess them if they qualify for privilege or not. And if they did, it would be obvious that there was a parliamentary matter, and they wouldn't be allowed to weigh up whether or not all these were proportionate responses or not to it, because it wouldn't be for the court to assess whether a case to Parliament, because they can't assess the case to Parliament because it's to Parliament, can't be adjudged in any place out of Parliament, so you can't assess whether it's a proportional, the actions they did were a proportional response. And that is the dilemma of the courts at the moment, that they're doing a hypocrisy to process and procedure.